I would like to give a floor to Mr. Graham Coop, partner from Volterra Fietta, United Kingdom. Please, Mr. Coop.
I am very pleased to be joining you virtually in Belgrade today. I have visited Belgrade on many previous occasions professionally, including as a speaker at the Serbian Energy Law Association conference a couple of years ago. And I sincerely regret not being able to join you physically in Belgrade today. But I hope that that will be a pleasure which will be delayed for only a short time. Okay, so my name is Graham Coop. I'm a partner at Volterra Fietta, a London-based international law firm. And I'm here to speak about the relevance of international law, and particularly investment protection law, to major energy and infrastructure projects in Serbia and other countries in the West Balkan region. So what is international law? I'll get straight to the point. International law is the body of legal system which governs relationships between countries and also between countries and private parties, including major investors. So investment protection law is a part of international law which has been created mainly by a wide network of treaties which have been signed between different countries over the last centuries, but particularly the last 30 or 40 years. Serbia has signed over 50 of these treaties with many countries, including most Western, Central and other Eastern European countries. And the purpose of these treaties is to provide reassurance to foreign investors wishing to make investments in different countries where they don't know much about the local legal system or the local courts, and they provide reassurance to foreign investors that their investments will be treated correctly. They don't guarantee that the investments will be profitable. They don't provide a guarantee against commercial risk. But the idea is to provide protection against political risk, which is something that foreign investors often find very difficult to manage. We all know that investments can take many different forms. They don't have to be shareholdings or sponsorship. They can also include finance from institutions like the EBRD. They can include major participation in project contracts, supply agreements, construction agreements, concession agreements, and they can include contributions in kind. So all these kinds of participation in projects can be considered investments. Now, Serbia, as I said, has signed about 50 investment protection treaties. I will take the treaty between Serbia and the United Kingdom as an example. But if you looked into any of the other treaties that Serbia has signed with France, with Belgium, with Croatia, with Turkey, you'd probably find much the same kind of regime. The treaty starts with a definition of investment and investor, and normally this definition is quite wide. So it covers any kind of asset owned by a foreign individual or a foreign company coming from the other country which has signed the treaty and which is invested in Serbia. So that's the definition of an investment. Then the treaty sets out a series of standards which the host country must respect. And it works both ways, so that the Serbia-UK treaty, for example, contains rules about how Serbia must treat investors from the UK, but the rules apply equally to how the UK must treat investors coming from Serbia. So they're bilateral treaties. So each treaty sets out rules, and these rules are well known in international law. They include things like fair and equitable treatment, non-discrimination, guarantee against expropriation unless accompanied by the payment of prompt, adequate, and effective compensation. Those are the main standards which countries that sign treaties have to live up to. Now, this, of course, does not take away the fact that individual countries have their own local legal standards as well. Most countries have a body of what we call administrative law, which determines how the government can act and says the government should not act unreasonably. And if you're an investor, local investor or a foreign investor, and you want to challenge a decision of the government, those countries offer you the opportunity to go to the local courts and ask the judge to set aside the decision made by the government. How well it works, of course, depends on how well the local courts work. Investment protection treaties do not take away these rights. They provide an added level of assurance, an added level of comfort for investors that come from another country which has signed a treaty with the host country, so that if the local courts don't work or they don't have confidence in the local courts, then they have the option of following their international remedies in the treaty instead. So the treaty contains a number of standards, as I explained, and if an investor thinks that its investment has been treated unfairly, if it thinks that the host government has not given it fair and equitable treatment, if it thinks the host government has expropriated it, if the host government has changed the law in a way which is disadvantageous to the project, imposes increased costs, reduces profits, imposes increased taxes and so forth, then normally the investor should have discussions with the government for a period of 3 months or 6 months. It's set out in the appropriate treaty. And after that, if those discussions don't work, then the investor has the right to start an international arbitration case against the host government. And this is what we call investor-state arbitration. So the Serbia-UK BIT, for example, offers investors the right to take their case to ICSID, the International Center for Settlement of Investment Disputes in Washington, or to the Court of Arbitration of the International Chamber of Commerce in Paris, or to what we call an ad hoc tribunal to be appointed under the arbitration rules of UNCITRAL, the United Nations Commission on International Trade Law. So these are 3 different but well-known international procedures which an investor can use to bring a case against the host government if it feels that its rights have not been respected. Now, investor-state arbitration is not fast and it is not cheap. Normally, an average investor-state arbitration case takes minimum 2 years to run from start to finish, more often 3 or 4. And normally, the legal bill for the investor or for the government will run into the millions rather than the thousands. So it's not a remedy which an investor would consider using for a trivial dispute. Any small disputes will be much better sorted out through consultation, negotiation, or through taking them to the local courts. But it does happen, of course, that an investor has a major problem with the government and that the government, the parties can't resolve the problem any other way. And so this investor-state arbitration system, imperfect though it undoubtedly is the best system that has been found so far for investors and governments to resolve major disputes about international investments. So this investor-state arbitration process will run its course for 2 or 3 or 4 years, and at the end of that time, the International Arbitral Tribunal, of whom one arbitrator has been chosen by each party, one by the investor, one by the government, and a third arbitrator chosen neutrally, will give its decision. We call this an award, and the award can then be enforced against the government if the government's been found to have done something unfair towards the investment, or against the investor if the investor has caused the government to suffer unnecessary cost. And this award can be enforced by a number of methods known to international law. So I was very interested in hearing the presentations earlier today, particularly the presentation of Mr. Bogdanovic in relation to the different kinds of investment opportunities that exist in Serbia at the moment. As previous speakers have correctly pointed out, there are many opportunities for developing the energy and infrastructure sectors in Serbia at the moment. These opportunities are too numerous for the state to finance them all. Private sector participation will be required, and the explanations of the gains to be made through energy efficiency in Serbia with the district heating, for example, with the electricity system, these opportunities all require financing, And all these kinds of financing, all the contributions that can be made by foreign investors to the improvement of energy efficiency and other energy and infrastructure issues in Serbia can all be considered investments under the provisions of investment protection treaties. So these treaties are very relevant to foreign investors which are considering making investments in Serbia, whether through the form of direct shareholding, through financing, or through some other kind of contractual contribution or contribution in kind. And they're also very relevant to the government of Serbia and to its local government entities, because they provide a guide as to how the government should conduct itself towards foreign investors, and they provide reassurance and make foreign investors more willing to come to Serbia because they know that they have this backup, this network of international treaties in case, for whatever reason, the local political system and the local courts do not give them
Sudovi ili
I think that basically brings me to the end of my initial remarks.
Da li se... Jedan, dva.
I think that brings me to the end of my initial remarks. This is a topic which one could discuss for several hours, and I'm very happy to do so with anyone who's interested, and I'd be very happy to respond to questions from any of the other panelists or from any member of the audience following the conclusion of my presentation. So thank you very much indeed for your attention. And once again, I am delighted to have had the opportunity to participate in this conference in Belgrade today.